Good morning, members. Although not everyone has been seated, we have reached the appointed time to start, so let's begin. So we start now. I know today your heart is not in room 2, but in room 3. But let me tell you that we have to keep a quorum of 3. If we don't have a quorum, I'm going to ask for a quorum call as chairman, and we may have to abort the meeting. All right, minutes of the last meeting have been sent to members. We haven't received any proposed amendments, so we confirm the minutes if members do not object. Today we have guests for this simple bill, Mr. Yang Yun-hong, Deputy Undersecretary, and Mrs. Wong, and also Senior Government Counsel, Ms. Ng. Let's ask the deputations to come in and join us. We have 2 deputations. One, Young DAB, Mr. Choi Tong Chow, representing Young DAB, and Mr. Fu, representing Hong Kong Professional Teachers Union. Please tune into the channel you required. Channel 0 is Flora, Channel 1 Cantonese, and Channel 2 English. So I'm going to give each deputation 4 minutes, so please be succinct in your speeches. Good morning. I'm Choi Tong Chow, representing Young DAB. In respect of this Education Amendment Bill 2013, we support the proposed amendments because that would align the provisions with MPF Ordinance Cap 485 so as to protect the retirement benefits of teachers working in subvented and aided schools. But why do we need to do this? Because there's a case, Mr. Ng, who was a teacher and he went bankrupt. The court ruled that in that case of Mr. Ng, the education ordinance could not act to protect his retirement benefits. At that point, the MPF ordinance have already been amended, effective the 13th of May 2011. So we really cannot understand why only after 18 months that the administration presented this bill. So efficiency on the part of the administration is really doubtful. If we have had more bankruptcy cases involving teachers, these people would be unfairly treated. In April 2011, Mr. Ng lodged an appeal, and he was granted leave, but things are now rather unclear. And that is to say, are we sure that after the amendments we are now considering are enacted, will Mr. Ng or teachers in similar cases be assisted? Or would there be other measures that the Education Bureau would take to help them? And apart from protecting the contributors to the aided and subvented schools, Provident Fund schemes, what about the DSS schools and other teachers? Are they going to be getting similar safeguards? If so, then when are we going to see legislative amendments so that the safeguards will be afforded? I have many classmates who are now teaching, and they have told me that teacher is a tough job. There are so many policies promulgated by the Education Bureau, by literacy, trilingualism, and medium of instruction, and so on and so forth. I hope the Education Bureau would do a good job for the sake of our younger generation. And we also encourage that the Education Bureau should encourage people to further their studies locally so as to improve our education system. These frontline teachers do a tough job. They work hard and they deserve retirement protection. Well, I'm generous. I won't stop you even if you digress. PTU, Mr. Zhang. Good morning. I'm from Hong Kong Professional Teachers Union. My name is Jiang Fu-wing. I won't talk a lot about the background. Let's go straight to the views of the PTU. We agree with the contents of the Education Amendment Bill because it would do away with the anomalies in the relevant laws, because the proposed amendments have taken into account the pensions ordinance, pension benefits ordinance, and also MPF ordinance. So it's proposed that after Section 85, bracket 3, there will be 2 more provisions in the Education Ordinance, and that is we are going to have bracket 4. If a Provident Fund member is an undischarged bankrupt, the rights or entitlement of member to any benefits in the fund, whether accrued, accruing, or to be accrued, is excluded from the property of the member for the purposes of the Bankruptcy Ordinance, Cap 6. Bracket 5, a new subsection. Subsection 4 does not apply in relation to a Provident Fund member's bankruptcy that is adjudicated before that subsection comes into operation. These are the views of the PTU. We also agree with the other amendment, and that is within 3 years after the closing of an Provident Fund's account, the benefit must be withdrawn. But the new amendment will enable the period with reference to the bankruptcy order not counted in this 3-year period. So the retirement protection of a bankrupt feature will not be affected because of this time limit of withdrawal. We believe the proposed bill would plug existing loopholes. It would also protect the property of schools in the subvented sector. On the other hand, the Provident Fund scheme can fulfill its original objectives, that is, the benefits are offered for retirement, so that the contributors will not lose part or all Provident Fund benefits because of bankruptcy after retirement. However, PTU is also of the view that it has taken 5 years after the relevant court judgment to present dispute on the amendments. It's really a belated effort. If there is bankruptcy involving teachers in the subvented sector in the 5-year period, they will not be protected by the amendment bill. We hope the administration can provide statistics on the number of cases of teachers involved in bankruptcy cases after August 2009. And we would also like to ascertain whether there any assistance of any nature will be offered to these bankrupt teachers.
First of all, legal advisor, can you talk a bit more about the legal aspect of the amendment? I understand that there have been some correspondences concerning that. When we viewed the amendment, we understand that for Section 85(4) of the ordinance, for the purposes of bankruptcy Cap 6, bankruptcy ordinance Cap 6, If a Provident Fund member is an undischarged bankrupt, this is actually the provision, which is different from the MPF ordinance, where it states declared bankruptcy. Well, in terms of the words used, they are different, but does it mean that they have the same definition or what? And for benefits accruing, it is different from accrued benefits under MPF. Apart from accumulated accrued effect, it also covers accrued, accruing, and to be accrued. Are they different? And what does it mean by to be accrued? If you can give us some concrete examples in relation to the contribution to provident funds by teachers, it would be helpful. Members, we agree on the purpose of the amendment. It's just that in terms of the details, the wordings in Chinese and English of the bill, they are creating confusion. Now, another question which has been raised by deputation is that, is it the case that teachers in directly subsidized schools are not covered? So can the administration take up this point? If not, please, if you cannot answer that, can you take up the first two questions? About the SS teachers, directly subsidized schools. We look at the schemes, the schools or the teachers drawn. For directly subsidized schools, they were actually changed from granted schools and subsidized schools. If a granted school or a grant school or subsidized school turns into a directly subsidized school, then in that case, teachers can still keep to the two schemes, and they will be covered by the amendment. If not, the school concerned will provide other schemes under MPF to the teachers, i.e., if teachers are under schemes other than the Provident Fund schemes, they will also be protected in other ways. So in any event, they will be protected. So I can't really say which provision provides protection to which teachers in the directly subsidized schools. As for the amendment, the amendment is in line with the amendment of the MPFO. No, they are two different ordinances, so in terms of the writing, they are different. For the wording in the Provident Fund, for avoidance of doubt, is so written. But after the ruling of the court, it was understood that the education ordinance could not protect teachers under the Provident Fund. So we propose that in case of bankruptcy, the contributor's benefits will not go to the official receiver. So in terms of the writing, the two ordinances may differ. We say if a Provident Fund member is an undischarged bankrupt, in this case, because we consider in case of bankruptcy, someone only enters the teaching field after being declared bankrupt. This is the scenario we considered. It's not the case that a bankrupt is a contributor who is bankrupt is not covered. So once someone joins the two schemes, he will be protected. He is entitled to benefits in the fund. For the Provident Fund Ordinance, both employer and employee has to contribute to the fund, and interest will be accumulated. Benefits under that is very clear and is in proportion to length of service. For example, in the first 10 years, government contributes 5%, and the next 10 to 15 years, 10%, and so on and so forth. As to the in some cases, the contribution may not be rewarded, given back to the contributor. Maybe it's because of professional misconduct. In that case, the contribution from the government will not be awarded to the contributor. So there are some uncertainties. Specific examples about accruing to be accrued, I'll defer to my colleagues. From DOJ, accruing and to be accrued. Let me supplement on that. Undersecretary mentioned that under the scheme, certain requirements have to be met. So it's hard to say how much is accrued or to be accrued at a certain period of time. Under Bankruptcy Ordinance Cap 6, definition of property is very broad, i.e. it covers benefits at present and benefits to be accrued. And so, under Cap 6, we have to consider future benefits too. That's why this is different from the definition in the court case. So we would like to make it clear by stating to be accrued and accruing will be covered. Any questions from members? Ms. Chen Yun Han. Thank you, Chair Lady. Now, I'm fine with the amendment, but we have to be specific. In case of bankruptcy, we're talking about teachers. Yes, I understand that. All right, about the teacher, I understand. There are different kinds of schools in Hong Kong, directly subsidized schools, subvented schools, grant schools. Now, people join different provident funds schemes But I don't quite understand what will happen to teachers in directly subsidized schools. For the teachers in subsidized schools, are we talking about directly subsidized schools? Directly subsidized schools, to put it simply, are not under these two ordinances. We focus on the GS and SS, that is grant schools and subsidized schools. For directly subsidized schools, most of them were grant and subsidized schools in the past. And teachers in those schools are actually working in a directly subsidized schools now. Mr. Young, I understand some teachers were not in grant schools or subsidized schools in the past. Now, for some left-wing schools, they are private schools. They were private schools. So those in private schools, they are not covered. So what will happen to them? For private schools, international schools, some new directly subsidized schools, teachers have to join MPF. And they will be protected under MPF ordinance. So they are protected under that ordinance. I would like to clarify. For example, a private school turns into a directly subsidized school and it goes bankrupt. And the official receiver line up to the creditor line up to make claims. Now, what will happen to these teachers in private schools? Are they covered in the amendment? For private schools, international schools under MPF ordinance, employees would not be affected by the state of property of the school itself. Now, in the market, there are different MPF schemes, and they have to make contribution for the employees.
供款個計劃同嗰個學校嘅財政本身已經係即係供咗款之後。
So the contributors' benefits are separate from the school's own assets. From my experience of handling such bankruptcy cases, usually there would be an order to freeze everything by the court. So are you saying that this part cannot be frozen? As I understand it, every year under the MPF ordinance, the 5% or $1,750 or whatever, let's say the 5% contribution, once contributed, would not become part of the school's own assets. So whatever happens to the school, warranting the freezing of its assets, the MPF benefits will not be affected. But in some cases, maybe the contribution is made annually, and then something happens before the contribution is made. There are provisions in the MPF ordinance to handle such a case. Please talk to MPFA and deal with this part as well. Well, I don't know much about international schools accounts or DSS schools or private schools for that matter. Please talk to MPFA to ascertain that things will be okay. Maybe I can ask my colleague to supplement. we ask schools to make special arrangements for their teachers' retirement benefits. Schools in the mainstreams are those schools which will be covered by the bill. Some teachers of DSS schools might already be covered because they used to work in GS or SS. And if not, then the school will have to come up with some arrangement under MPF. And if MPF protects all working employees in Hong Kong, so the protection will equally apply to these teachers. So if the school goes under, becomes bankrupt, well, they would have the teachers will have the same protection as other employees. There will not be a special arrangement for teachers. So private schools are just like any other employers, and their teachers are protected under MPF like other employees. Maybe the Bureau can tell us that for the subsidized schools and grant schools, there are two sources of funding, or there are two retirement schemes, MPF and the Provident Fund for subsidized schools. Is that the case? Oh, so my turn? No, Mr. Professor Kenneth Chan. Well, as I understand it, it's not quite the same as you have said. There are, in the main, three types DSS schools. They are under the MPF. And there are, of course, some cases whereby they were previously subsidized schools. So they have a Provident Fund scheme, and they are not under the MPF. And also the same for grant schools. They have a Provident Fund. So each type has its own Provident Fund. I believe this is factual. But for the schools, their Provident Fund funds are better than the employees at large. Yes. According to my experience, the Provident funds for teachers in the GS or SS are better. So if these schools in grant schools and subsidized schools are getting better treatment, why don't you offer the same to those who are teaching in private schools and DSS schools? I believe we are going to ask these questions sooner or later. Well, also, occupational retirement scheme would be better than MPF generally. So why not give the same treatment to DSS schools? Professor Chan, I think this is a belated bill. Maybe people have the impression that there was some oversight on the part of the administration in the last amendment exercise, and it took a court case to jot the administration into action. And we have a representative from PTU pointing out that this bill is presented 5 years after the court case, and now the administration wants to plug the loopholes. But PTU would also like to get some statistics on the number of bankrupt teachers since or after August 2009, and whether any assistance will be offered to these teachers. Of course, it's not directly related to this present bill, because we are forward-looking, and the administration has indicated that the bill is not going to be retrospective in effect. But for social justice or on compassionate grounds, maybe the administration should tell us the figures, the statistics, because there is a gap or there is a perceived loophole. Maybe more should be done on compassionate grounds to compensate the teachers concerned. May I get a response from the administration? Undersecretary, since 2009 to this year, to 2013, 09101112, 091011, we have 3 cases of teachers going bankrupt every year. And then if we take into account this year as well, there are altogether 11. And if we took into account the period after May 2011, there have been 4 such cases. As I've explained, MPF is somewhat different. It's easier to amend the MPF ordinance. If we look at the wording of those, those provisions, it's easier because the provisions state that it's just for clarity's sake. But in this case, the court found the provision problematic. So we thought it would be more prudent to see if there would be a final judgment from the Court of Final Appeal, or would higher courts came to a different interpretation. So that's why we thought we should wait whether there are other views to be expressed by the Court of Final Appeal. So more time was spent on keeping an eye on this case and to monitor whether there would be an appeal lodged by the teacher. Well, up to 2012, there have been 2 attempts to seek leave by the teacher concerned. So if there is going to be an appeal after all, maybe the Court of Final Appeal would say something in addition to the lower court's judgment, and we may need to amend a few more things. So we did something to get prepared. But now we have reached the stage where we think it's not very ideal or desirable to wait. But theoretically, the teacher concerned can still lodge an appeal. But still, well, we have waited for so long. And we're talking about more than 3 years after 2009. We believe it's time we act. Looking back, well, you may ask why we didn't do it earlier. But if 2011, 2012, there were uncertainties because the teacher might lodge an appeal, and we might have to change the law more than once, or maybe the court would come to a ruling that the wording is okay. Then we may have to just insert an avoidance of doubt provisions. I'm not trying to explain why we have done this, but I just want to point out that there were a lot of things in the period concerned, and also whether do we have a lot of people affected because the amendments have not been moved earlier. Well, I think we have to make arrangements according to what things stand. it's difficult to compensate these people because they were subject to the old law. But we are willing to look at individual cases. But as a matter of system, it's difficult for us to offer assistance to these people. Madam Chair, I want to clarify something. There's nothing, according to the administration, that can be done in the system or in the bill. But they are willing to look at individual cases. So exactly what are you going to do? I know you are constrained by the law. But can you give us or indicate the directions that we all need to go to assist those affected? By looking at individual cases, I will certainly, we are willing to see what can be done to assist them under the system. But if we just disregard the background and offer special assistance, that's not what we are going to do. We cannot do that.
But after the passage of the bill, what will happen to the bankrupt teachers? What does it mean? The contribution will be protected? Now, with the bill is passed, for the bankrupt cases, they will be protected. For those declared bankrupt before the passage of the bill, they will not be protected. So this is exactly the question I had in mind when reading the amendments. You propose to give protection to these bankrupt. At present, the official receiver can take away all the contribution from the fund, so at present they do not have protection. What if the bankrupt is still working? So there will be future contributions too. Will the contribution be protected? And if he is declared bankrupt before the passage of the bill, then he will have to contribute, even though the contribution will not go into him in the end. Contribution after declaration of bankrupt goes to the contributor. The official receiver can only take contribution before the bankruptcy. So bankruptcy before the passage of the bill will be handled in this way. It's just that bankruptcy after the passage of the bill, the bankrupt will be protected. That means the trustee in bankruptcy cannot touch the contribution in the fund. So before the passage of the bill, the contribution will go to the trustee in bankruptcy. So, Mr. Kenneth Chan, if the causes of the bankruptcy is due to high property price, then the government has to bear much responsibility. Can I understand that the three scenarios, say in para 4, in the background brief in para 4, where it talks about Sau-lan case, Now, at that time, there were two ways to deal with such cases, but now you propose to amend the bill, then there will be a third way to deal with it. Before the case, all the contribution in the fund, including the contribution after declaration of bankruptcy, all this will go to trustee in bankruptcy. After the ruling of the Court of Appeal, there is another way to deal with it. That is, only the post-discharge services are paid to contributors. Now, after the amendment of the bill, then all the contributions will be protected. Now, my question is about the practice before the case of Ng Xiu Fan. Were there anyone affected? If so, after the passage of the bill, will these people be affected? Will the accrued contribution to the fund be affected? This is a complicated matter. I don't know whether I put forward a clear enough question. So can you reply to that? Were there any people affected before the court's ruling? That is, their contribution is not protected. That means the contribution will go to the creditor. And if so, how will these group of people be affected after the passage of the bill? Will they get any protection after the passage of the bill, or what? Chair Lady, let me try to explain it in this way. The Court of Appeal made a ruling in 2009 that the trustee in bankruptcy would not take all the contributions of contributors. Post-discharge services actually goes to the contributors. So people went bankrupt before the ruling who have also reached retirement age and they already got payment from the government, then all the contributions would go to the trustee in bankruptcy, the TIB. Whereas for those who are still making contributions after the 2009 ruling, with a clearer definition, for this group of people, they haven't reached the retirement age. They haven't got the pension from government yet. And we reached an agreement with the official receiver for these people. Pre-discharge benefits are paid to the TIB up to the retirement age, and the balance would go to the contributor in the end. Bankruptcy after passage of bill will not encounter this situation. That means all the contributions would go to the contributor under the two schemes. I don't know whether I help in any way. Let me see if I understand it correctly. We're talking about three groups of people. Those bankrupt before 2009 and those bankrupt after 2009 and those who go bankrupt after passage of bill. I was asking about those people who went bankrupt before 2009. According to what you said, the future contributions, if any, would go to the contributors, would go to his account rather than the TIB. That's in accordance with the court's ruling, is that right? In that case, if that's the case, then I think my question has been answered. My second question is related to Mr. Kenneth Chan's. There is an interim period, a vacuum period, Now, after the passage of the amendment, we offer better protection. But before that, say, for example, in the next couple of days, a teacher goes bankrupt. That's before the passage of the amendment. So the contribution, say, up to millions of dollars, would go to the drains, would go to the creditors. But after the passage of the amendment, the contributions would go back to him. This person may go bankrupt because of property price, because of mortgage. But because of the vacuum period, he is dealt differently. It's a minor amendment only. I think you can implement it earlier. The teacher is already very unfortunate, and he has to suffer during the vacuum period. Can you do something to help him? I understand that there is no retrospective effect, but we are talking about a small number of such teachers only. But the amendment will affect his life in the long run. So can you do something, say by administrative means or legislative means, and what can you do? How far can you go for these people? Chair Lady, we're talking about principles here. There are two types of benefits we have to concern in bankruptcy cases, that of the creditor and that of the debtor. So we have to strike a balance here. Well, at this moment, we look back and we may say we could have done something earlier on, but looking at the full picture, at every step, the government has taken into account the situation at that time, and we have already expedited things and do everything possible we can. We don't want any group of people who suffer unfair treatment because we are late. Now, Mr. Ip, you mentioned what will happen to people who go bankrupt in the next couple of days. We can only say they will be dealt with according to the prevailing laws. This is to treat the creditor fairly also, because everyone is acting in accordance to the law, and the government cannot take away their rights. The government also plays according to the prevailing rules. It's far hard for us to compensate for just a group of people. Some people may even push it further to an even earlier date. So we do not offer retrospective effect in laws because it's not pleasant. It's not appropriate for us to go back after laws have been set. Some people go bankrupt because of reasons out of their control, but some not. So it's difficult for us to comment who deserve our help, who not. When someone cannot meet the daily needs, the government has the responsibility to help these people. But for people who lose in investment and ask for government's compensation, I think it's hard for us to give a reason to help them. I think I have already given you a very clear answer. There will be no retrospective effect, Ms. A. Now I want to comment on Undersecretary's reply. I have to say something on behalf of those who go bankrupt. You say they go bankrupt because of various reasons, and the government will have to make some differentiation as to who to help and who not. That's not the case. Some people are dismissed because of moral reason or because of something they've done. But for others, that's not the case, so you should not take away their contributions. So whether the bankruptcy is a result of their own decisions or not is really irrelevant. The crux of the matter is the contributions should not be taken away from them. So you really have to think about this vacuum period. And the government has a responsibility to protect the contributions in the Provident Fund. Because of this vacuum period, certain teachers are not covered. And this is a long-term effect. Can you do something about it? Now imagine something like that happen to your friends or anyone here. Then you will feel the pain. So you have to see what you can do by ways of administration or legislative means. I understand that you may have constraints, but can you go back and think about what you can do? A third question.
The coverage of the bill is such that DSS schools might or might not be covered. If the teachers used to teach in subsidized schools or grant schools, and they have chosen to remain in such provident funds instead of joining an MPF scheme, so they will remain within the GSPF or SSPF, notwithstanding the fact that I am teaching in a DSS school. So I'm still a participant in either GSPF or SSPF instead of a participant of a MPF scheme. Can I have a clarification that this is correct? There are two systems. One is called grant schools, the other subsidized schools. Grant schools are those with a longer history, St. Joseph and the like. For such schools, if they then became DSS schools, the control board, the Grant Schools Council, has decided they can continue to contribute to the GSPF. These teachers can still remain with the GSPF. But for DSS schools, Some teachers might used to be GSPF contributor. And in our DSS subvention, we already included the government's contribution to the GSPF. In the unit cost of a student, this factor is included. And under the MPF ordinance, DSS schools have to offer MPF benefits to their teachers. So normally, the DSS schools would choose a suitable MPF schemes to the teachers. So in DSS schools, there may be two different categories of teachers, as well as provident fund status is concerned. All right, let's proceed to cross by cross. Please refer to CB4 583 1213 bracket 02 for the markup copy, and you may also refer to the group bill 85. The administration or the DFJ. We have to look at the long title. Oh yes, I was looking at the blue bill. So let's look at the title. And the bill is to provide for protection to Provident Fund members in case of bankruptcy of their benefits in Provident Funds that are maintained under the Education Ordinance. So the bill aims at protecting these Provident Fund members. Okay? Long title, or short title rather, clause 1. This ordinance may be cited as the Education Amendment Ordinance 2013. So can we move on? Any comment on the short title? Next, do you have a commencement date? Well, it would commence as soon as it's passed by the Council. Clause 2. Enactments amended. The enactments specified in parts 2 and 3 are amended. And then we can look at the markup copy now. Part 2. And that is clause 3. We propose to amend Section 85 of the Education Ordinance, rules for Provident Funds. And after Section 85, bracket 3, we will add 85, bracket 4, which clearly provides protection for undischarged bankrupt. If a Provident Fund member is an undisclosed benefit, the right or entitlement of the member to any benefits in the fund, whether accrued, accruing, or to be accrued, is excluded from the property of the member for the purposes of the Bankruptcy Ordinance, Cap 6. The purpose is that when Bankruptcy Ordinance is applied to determine whether someone's property is to be taken into account, then the benefits of the Provident Fund will not be covered. Such benefits will be excluded from the property. All right, members, comments on Section 85, bracket 4? All right, now Section 85, bracket 5. We point out the effective date. Section 85.5 stipulates that subsection 4 would take effect after that subsection comes into operation. Although some of us works in the education field, well, the Legislative Council brief is difficult to understand. Maybe we can be given a table with a timeline, because in different times they are different in coverage. So please don't be superstitious about the power of the word. Please tell us when, what would happen at different times, and what kind of benefits will be protected if the bankruptcy takes place at a certain time. It would be easy to give us a matrix, a table, instead of writing 20 paragraphs, which are still difficult to comprehend by teachers here. That's a good suggestion. You have so many people in the Education Bureau preparing teaching materials, so why do you have to do this for a legislative brief? All right, if there's no further comment on Part 2, we can proceed to Part 3, amendment to the Grant School Provident Fund rules. Madam Chair, we are going to amend the two sets of rules. That is Grant Schools Provident Fund rules, Cap 279C, and Subsidized Schools Provident Funds rule, Cap 279D. The two sets of amendments are identical. So when contributors reached a stage whereby he can withdraw the benefits, he must do it within 3 years. And this amendment is about how to count the 3-year period. If at the time of retirement there's still 1 more year for the bankruptcy period to go, then the period during which he is bankrupt will not be counted towards the period of 3 years, because the early withdrawal of benefits would not belong to him. It would go to the trustee in bankruptcy. So the purpose here is to offer protection. And also after Rule 14.2, we add bracket 2A and bracket 2B. And that is if there's any time when the contributor is in a discharge bankruptcy, then that period will not be counted towards the period of 3 years. And also in bracket 2B, similarly, which stipulates that paragraph 2A would start to apply after 2A comes into operation. And then clause 5 is identical to clause 4, just that one set applies to grant schools and another to subsidized schools. Correct. All right, members, do you have any questions about Part 3 and the amendments? And also explanatory memorandum. Well, we'll talk about this at length today. Paragraph 1. We talk about why we need to add new sections 85, bracket 4 and 5. And then paragraph 2, we talk about why we need to amend the two pieces of subsidiary legislation. All right? If members have no further questions, then we have completed the clause-by-clause examination. I would like to ask the legal advisor to see if there's any problem with the Chinese version in terms of consistency with the English version. And also, Clark, please tell us the timetable since we have completed the scrutiny today. So we completed the cross by cross and also actually the examination of the whole bill. We can submit a report to the House Committee next Friday or the 31st of May. So when are we going to resume the second reading? If we do this on the 31st of May, then the administration can move for the resumption of second reading at the next council meeting. I don't think the filibuster will affect this, because we are talking about adoption of certain heads into the appropriation bill. That won't take a long time. So, thank you. When's the deadline for moving amendment? I don't expect any, but what if there's amendment? The deadline is the 8th of June, and I don't expect any amendment from members. All right, thank you for coming to this meeting.